Hello, everyone, and thank you for joining today's webinar, Resilience in the Evolving Standard of Care, Series Part 3, Legal Perspectives. As you get settled, please feel free to say hello and where you're joining from in the chat today. To qualify for continuing education credit, AIA California provides the learning objectives for every webinar and includes them in the PDF presentation that can be made available online. We will provide links in the chat box where you can find upcoming and on-demand climate action and ZNCD webinars from AIA California. A few housekeeping reminders. Today's session is being recorded and qualifies for 1.5 AIA HSW learning units. For those who stay on and watch live, AIA California staff will report these units for you. Please use the Q&A function to ask any questions for today's presenters. You can also like a question to move it to the top of the queue. Please be constructive in your comments and questions to help foster a positive learning experience for everyone. Finally, AIA California's climate action programming is now brought to you by Arup. Sustainable development is everything. I'd now like to introduce our moderator for today. Oh, before we do that, because today's program is on legal perspectives, we did want to share just this comment for everybody. This presentation is for general informational purposes only. Nothing presented herein should be interpreted as legal advice of determination of coverage. For advice tailored to your specific situation, consult with your attorney. Additionally, only the insurance policy can give actual terms, coverage, amounts, conditions, and exclusions. Program availability and coverage are subject to individual underwriting criteria. AIA California's programs are protected by US copyright laws. Use without our permission is strictly prohibited. Now that that's out of the way, our moderator today is Sammy Shams, AIA NCARB, Lead AP, BD plus C, Well AP, Fitwell Ambassador, and LFA. Sammy is a sustainable design leader in healthcare at HKS, working in Design Green. HKS is Building Performance and Sustainability Group, focusing on sustainable, healthy, and resilient buildings. He is also co-chair of the AIA Resilience and Disaster Response Committee, or RADAR, and co-author of the AIA and HKS Resilience Design Toolkit. Thank you so much, Sammy, for being here, and I will hand it over to you.
Thank you, Sarah. Integrating resilience into architectural projects requires identification and understanding of the risks and impacts from potential hazards. This allows professionals to develop mitigation strategies, ascertain potential costs, and determine length of recovery time. Resiliency is distinct yet inherently linked to sustainability and building performance. Design and construction approaches that aspire for zero carbon buildings must consider resilience, sustainability, and building performance strategies to achieve this goal. A climate responsive building enables more efficient operations, more durable components to minimize damage and downtime, and an overall reduction of carbon footprint. These concepts are linked and critical to achieving zero carbon design. Resilient, sustainable, and net zero carbon meets a contemporary definition of the architect's standard of care that is currently beyond code, yet code compliant. To achieve this standard requires an understanding of the legal landscape. Today's presenters will address the case law, the issues of resilient buildings, and standard of care beyond minimum code compliance, and will discuss how to avoid negligence when providing architectural services that are resilient, sustainable, and low to zero carbon. Next slide. Today's three attorneys will present in this order. Yvonne Castillo, Esquire, is Senior Vice President in Risk Management at Victor US. She's an expert in risk management and public policy with over 30 years of experience as a licensed attorney. At Victor US, she leads a team advising architecture and engineering firms on strategic risks, including climate liability and green building standards. Jessica Mead, Esquire, is a partner at Collins & Collins, where she defends cases on behalf of design professionals, architects, engineers, judges, and lawyers. And finally, Brian K. Smith, Esquire, is managing partner at Collins & Collins and handles professional liability and catastrophic injury matters and represents design professionals in all aspects of practice, such as contract review and negotiation, mediation, arbitration, and trial. Thank you all so much for being here with us today. Please take it away, Yvonne.
All right. Can you hear me? Lee?
Yep.
Everybody hearing me? Okay, awesome. Great. All right. Well, thank you very much. First of all, AIA California Council for inviting me to speak here today. As Sammy said, I'm the Senior Vice President for Victor Insurance Managers. We are a professional liability insurance underwriter. For those of you not familiar with Victor Insurance, we are the exclusive underwriting arm for CNA's Architects and Engineers Professional Liability Program. So if you're a CNA policyholder, you're also a client of ours. We're not just your underwriters, but we're also your risk management guidance or advisors. And I manage our risk advisory department, and we're a team of 7, including myself. And it's really an honor actually to be invited to be part of this conversation today, because there's a lot going on at the intersection of climate change, extreme weather, and architectural practice. So this is a very timely webinar, and I hope that at the end of it, you'll feel you have more information, you understand better what those risks look like. And so we'll go ahead and kick it off. If you could go ahead, please, just Sarah, move. Yeah, thank you. All right, so the first thing I thought we could do that would be helpful and is kind of foundational to everything we're going to be talking about today is go through a bit of current state and future state on climate change projections. If you could go ahead and advance, please. Next slide. And to do that, I think it'd be useful to kind of look at NOAA data. NOAA is the National Oceanic and Atmospheric Administration. As I'm sure many of you all are aware, have seen this chart, but if you haven't, this is the chart that shows activities through 2024, the year 2024. So you're not going to see 25 information on this slide, but you'll note on the slide that it does say it was updated January 10th. So it is a complete picture, most complete picture through 2024. And just to orient you to the slide and the information here, the x-axis, that's the number of, the y-axis is the number of events on the vertical. And what we're talking about is billion-dollar climate-related disaster events. And then the x-axis is the timeline since 1980, since NOAA has been tracking these events. And then harder to see on this slide is that roller coaster line that kind of goes through the bar charts. There's a reddish brown line on the chart that shows essentially the costs associated with these events, and this is inflation adjusted. So you can see if you look to the far right, the last bar chart or bar on that chart, that's a complete picture of 2024. And as you can see, there were 27 separate billion-dollar or more weather and climate disaster events. And the total cost of those events, at least at the present time, and you can, again, it's that reddish brown line, it's 182.7 billion, and that number is and counting. So the website says they're still kind of tallying. I'm assuming Helene and Milton, but 182.7 billion for last year. What's notable about that cost is that's almost 100% increase from the year before, which was 92.9 billion in 2023. And then, of course, now we have 2025, the LA wildfires, and what happened there, projections for worsening conditions, what we're going to talk about in a moment. I suspect that this number that we're seeing in 2024 is probably going to be easily eclipsed based on the LA wildfires by themselves. So it's just kind of shows you a rather stark picture of what we're up against. But the other thing I want to talk about related to this chart that I think is important takeaway, it's not just about the severity and cost in these recent events. It's really the frequency in which we're experiencing these events in the United States and globally. So if you kind of zoom out a little bit on this chart over the last 45 years, you can kind of see there's a trend that's been that's shifted. If you could click, please, on that slide. If you look between 1980 to about 2010, Mark, you can see, generally speaking, we weren't really hitting anything over in terms of number of events at this level over 12 events. And then you see this kind of shift that happens around 2010. There are a number of reasons that are being, considered by the climate science community around this. But I'd say the biggest reason or driver for this shift and change in the frequency of these events is related to the consensus by the scientific community around rising greenhouse gas emissions in our atmosphere, and then the consequential warming, which is impacting the physical events that we're experiencing today. Next slide, please. So what I want to talk about now is I want to kind of focus in on global warming a bit. Again, this is foundational to what we're going to be talking about for the rest of the program. But I think what's important here is there's a baseline level of understanding what the Intergovernmental Panel on Climate Change, this is the leading international body for climate science around the world, what they're saying. And we're going to do that by looking at their synthesis report from 2023. So that was the last big report they put together on climate science and where we are as a planet. But the first slide here is just a small excerpt from that report. I encourage you to read the whole report for yourself. But according to the Intergovernmental Panel on Climate Change, IPCC, human activities, principally through emissions of greenhouse gases, have unequivocally caused global warming, with global surface temperatures reaching 1.1 degrees Celsius above pre-industrial levels in the decade 2011 to 2020. So as you all know, climate change is measured over decades. It's not measured year to year. It's usually 30-year time periods. So the information that was reported, again, this was in 2023, this at the beginning of 2023, this did not include what happened last year or in 2023 in terms of a full year. And as you know, you probably remember the headlines in 2023 at the end. It was the hottest year on record, with almost half of the year exceeding 1.5 degrees of additional warming. So this slide is actually already old based on the accelerated warming we're experiencing. And then last year, 2024, shattered the previous year's record, where the full year was actually exceeding that 1.5 limit. So we surpassed that. So the question now in the climate scientific community is, okay, what can we expect for 2025? Accelerating warming trends, which they're all trying to figure out, why are things happening at a quicker pace than originally anticipated? Next slide, please. And what the report essentially predicted, I guess, is really important. So again, in 2023, what the report said was that continued greenhouse gas emissions are going to lead to increasing global warming, with the best estimate of reaching 1.5 degrees in the near term in considered scenarios and model pathways. So as many of you know, we've already, as I just stated, we've already kind of hit that point, at least for last year. Climate, as I said, you know, it's measured over decadal timeframes. But what's concerning about this particular slide is that what they are saying is that even what we've hit already at 1.5 is near term. And you may remember the Paris Agreement that was signed back in 2015. At that point, the global scientific community was basically saying, we really can't afford to hit 1.5. 2 degrees is the max we could potentially get without reaching catastrophic events. So what we're concerned about here is that we've already hit that 1.5 degree in the near term. So let's move on to go ahead and move to the next slide. So what does that mean for hazards and for you in the built environment in terms of global warming? What the scientific community is saying is that every increment of 0.1 degrees of global warming is going to intensify multiple and concurrent hazards, and that's with high degrees of confidence. They are also saying here on this slide is that deep, rapid, and sustained reductions in greenhouse gas emissions are going to lead to discernible slowdown in global warming, but they're caveating that language with within around 2 decades. So what's important about that, and this was kind of a light bulb moment for me personally, is they are saying that even with even if the world, the United States, drastically pivots and we completely change our use of energy through energy efficiency or through fuel switching, electric buildings or electric vehicles, what they're essentially saying is they're clarifying that the heat trapping emissions that exist right now in our atmosphere that have accumulated over the past decades, those cannot be removed with any at any meaningful scale, because we really don't have the technology to do that right now. So what they're warning is that even in a dramatic situation where the world pivots, it's still going to take about 20 years for the planet to feel the positive impacts of today's reduction in emissions. And as we all know, if you've looked at the emissions trajectory, we've not abated that line. It continues to go up and up. So I'm imagining this delay is metaphorically akin to the image I have on this slide, as, you know, trying to slam the brakes on a speeding train. It's going to take some time for the global climate system to actually react to reduced emissions today. And so what that tells us, for those of you designing and building and planning our communities, what it tells us is that we're already in a precarious situation in terms of global warming and the physical impacts that we're going to be experiencing every single year. And it means that global societies in the US need to adapt quickly to prepare for these impacts that are already locked into our climate system. Next slide, please. Okay, so now that we've talked about climate projections, what to anticipate for the coming years, you can go ahead and switch. Next slide, please. I think it's important to kind of figure out, okay, so how are your peers in the design and construction industry, how are they reacting to these growing challenges and these realities and the physical risks that are that we have in the built environment? The big question that we get as an insurance company underwriting professional liability insurance is, has the standard of care changed in response to the frequency and severity of climate-driven events? And the answer is, please click on the next, yeah, if you could click through, Sarah, thank you. The answer is it's changing. The reality is that it's a moving target right now, and we're going to talk about that in a minute about the standard of care. If you could go ahead and advance to the next slide. So the standard of care is, everybody knows, it's what you do on a daily basis to manage your projects. It's what your peers are doing in your locality, how you're managing your projects, and how you're exercising reasonable professional judgment on your projects. But it's the important piece that I don't think is understood here is that is literally inextricably linked to the legal standard of care. So when a court or a jury is in the process of reviewing, for example, a negligence claim against a design professional, they're going to be looking at what the industry standard of care was at the time that the design was completed. They're going to look at what your peers were doing in your locality. So it's super important that you understand that the legal standard of care is very focused on what is happening at the time of the design and what your peers are doing. Another metaphor to understand the industry standard of practice, can you please advance to next slide? Is this metaphor. I graduated from architecture to school before I went to law school, so I'm always thinking in images, and it seems to be helpful to talk about the standard of care with these kinds of metaphors. But if you'll indulge me for a second, imagine in this school of fish metaphor that your firm is one of these fish in this image. So the neat, clean boundaries around the school of fish, these are the established standards and practices for licensed practice. And the purpose, of course, with this boundary is to ensure some level of consistency, safety, and reliability in licensed practice. So in theory, as long as your firm, you're practicing within those boundaries, theoretically, you should be safe from legal liability. But climate change, unfortunately, is really disrupting that neat, clean boundary. Next slide, please. So we view climate change as kind of a force multiplier in the standard of care and impacting the standard of care. And what I mean by that is, in reaction to recent severe weather events and projections for worsening conditions in certain locations in the United States, firms are starting to do their own thing around resiliency. And unfortunately, as you can see in this image, there are no consistent standards of practice around resiliency. The folks on this call and many of your leaders and within the AIA and throughout the AE community, those things are starting to change, and that boundary is starting to solidify, but we're definitely in the early stages, unfortunately. So it's really hard for you as a firm to know, are you in bounds? Are you not doing what you're supposed to be to stay within those boundaries? Or is your firm exposed to potential liability? So some of the disruptors that I'm trying to depict here in this image is, we're seeing things like some firms are just being proactive and designing above code, so they're doing their own thing. We're seeing some professional associations are starting to impose ethical obligations for their members to integrate climate adaptive design thinking. Especially top of mind is the AIA Code of Ethics, which is much more stringent than most professional associations. It states that architects should provide clients with a built environment that is resistant to climate change, in quotes, and quote, should incorporate adaptation strategies with their clients to anticipate extreme weather events and minimize adverse effects. So that's a pretty very clear expectation from the AIA and their members. Municipal governments on this slide. So we're starting to see municipal governments are developing very prescriptive resiliency design guidelines that provide specific design interventions for heat, for stormwater, for flooding. And I'm thinking about New York City, Boston, Miami, I believe, is developing some resiliency standards. I think that work is happening in California. So I'll leave it to the California experts to talk more about that. But we're seeing state governments are also developing and publishing hazard mitigation plans, adaptation plans. We're also starting to see the code world try to catch up and start to integrate future forward climate data. And what I mean by that is you may be aware that the newest edition of the ASCE 7, it includes a supplement, and that supplement addresses how climate change is impacting flooding and sea level rise. And it's shifting the design basis for most building types from a 100-year flood event to a 500-year flood event. And then also just recently in the last couple of months, there's a new ASTM standard for property resilience assessments, accounting for future climate risks in commercial spaces. And then finally on this slide, there are two recent studies that I wanted to touch on, but I think these studies are going to give you some insight in how your peers and how the industry is reacting and changing their practices in response to climate-induced weather events. Next slide, please. So the first study I want to touch on really quickly here, this is an AIA resiliency study. You can see on the corner here, the title of the study. You can download it. It's called Resiliency in the Built Environment Research Report, done by AIA and Owens Corning. Certainly read the report yourself. I was looking at it through the lens as a professional liability company, but some of the bigger points I thought were interesting here is the first point. The vast majority of the architects who responded in this study, they believe code does not make a building resilient enough for its location and will not enable buildings to withstand all likely hazards in their locations. This is interesting, in particular, when you contrast it to two other groups that responded in the study, and it was architects, it was clients and contractors. So when you look at what the clients and the contractors said on this point, they believe the absolute opposite. They believe that if you design a building to meet code, it's going to make the building resilient enough for its location, and it's going to enable the building to withstand all likely hazards in their locations. That is very interesting. I'll talk more about that from a professional liability standpoint. But just briefly, architects, the third bullet here, architects reported that site exposure to natural hazards, climate impacts was ranked as one of the more important considerations, ranking it third out of 13 resiliency considerations. About a third of architects reported that they are relying on climate projection data, and then a quarter of the projects reported going beyond code. So again, read the report in full. These are just things I kind of stood out to me. But from a professional liability standpoint, those first 2 points, it is really notable that there's such a wide gap in misunderstandings about what code does and does not do to make a building resilient for its location. Because based on our claims experience, and we're talking, the first in this business, we've been around for 60-something years. When we look at the drivers for claims in our book of business, it has always been largely based on miscommunications among stakeholders, misunderstandings or misaligned expectations around responsibilities. So that was kind of a glaring point. Next slide, please. This next study is a unique one of its kind study. We've not seen this done yet other than this particular one. So this was, it's called Climate Forward, How Climate Projections Aren't Used to Inform Design. This was done by HGA and University of Minnesota Climate Adaptation Project. A relatively recent study, and the focus of this study was to understand whether the industry was moving toward the usage of future forward climate projection data versus the standard practice of just using past weather data files to inform design. The group or the respondents that were in this profile of respondents that were in this study, a little different from the AIA study that I just talked about, because this study included not only architects, but also engineers, planners, and sustainability specialists. So if you could click, please, on the first bullet. So again, these are just high points on this particular study. First of all, I thought was interesting was that more than a third of the respondents offer climate resilience adaptation planning and design services. Next bullet, please. You can click through actually all of these. That's fine if you just want to click through all of them. 93% noted some familiarity with climate future projection data, and about a third use this data to inform design planning. The majority of respondents are using future forward data from publications like the IPCC study or information that I was talking about earlier, and regional fact sheets. They're not necessarily using raw scientific data. And then the biggest use case for climate projection data is to inform conversations with clients, climate risk assessments, and site building design strategies, slightly less so for system sizing design decisions. And then the final is, and again, I'm looking at it through the lens of a professional liability carrier, but the biggest barrier in using future forward climate data is that clients aren't asking for it. So all of these slides are important, but that last bullet from a liability standpoint really caught my eye, because in a negligence case, courts and jurors are likely not going to align with that kind of defense that you said, well, my client didn't ask me to consider future forward data consideration. Case law tells us that a safer approach, at least from a liability standpoint, is for firms to proactively talk to clients about the likely impacts of increased frequency and intensity of weather events, document those conversations, especially those instances where you've got a client that is declining to invest in adaptive strategies, but you're making recommendations to do so or to explore those strategies. So it's really important. We'll talk about that later in the program on risk management. But my point here is waiting on your client to ask you to consider future forward climate data. It may be a riskier approach from our viewpoint, from a liability standpoint, because the reasonable standard of care is going to assume that the professional knows more about the physical risks relating to a physical asset that you're designing and building for your client. All right, so now we've talked about industry reaction. We've discussed some of the changes that are occurring. You now understand some of the studies to give you some better sense of what your peers may be doing in terms of changing industry standard and therefore impacting the legal standard of care. Now I want to switch gears a little bit and give you some insight into how courts and how they analyze negligence cases and how that is going to potentially leak into climate change cases as we move forward. Specifically, I'm going to focus on the element of foreseeability, which is an important element. It's a legal element within a negligence claim. It's whether or not a design professional could or should have reasonably anticipated certain risks. And in this context, we're talking about climate change risks. So we'll go ahead and advance to the next slide, please. All right, so I'm sorry, one more. You can move forward. So the first case we're going to look at, this is the LH Bell case. Don't know if you've heard of it before. This is in Arizona. The law is still timely. It is a case that is cited throughout the country. But looking just at this case first, I'm going to go through the timeline on the right-hand side of the screen just to kind of orient you to what, critical milestones and dates. And then we're going to talk about the physical site, and so that you can understand how the claim evolved. So first of all, before the engineer, and this involved an engineer, before the engineer was hired by the county to design a bridge and the approaches to the bridge, there was a 50-year flood event in 1967 at the project site. So you can see that here on the slide. And then the engineer defendant was hired 2 years later by the county in 1969 to design a bridge to meet FEMA's 25-year flood designation. And then after that, almost immediately after the project was completed, there was a 100-year flood event that occurred in the area where the loss occurred in September of 1970. All right, so looking at the actual site here on the left-hand side of the slide, in dark blue, you can see that's the New River. And you can see in light blue, there are gullies that ran over the land that fed into the New River at certain points. And then across the top, it's hard to see, but there's a dike that was constructed on the land. It's in gray, kind of goes through those gullies. And then in hash marks here on the slide, this is what the engineer was contracted to do for the county. So the engineer was contracted to not only design the bridge to go over the New River and to withstand that 25-year flood designation, but also here the engineer was expected to design the approaches, of course, to the bridge on both sides. And one thing that's really important in this case that I can't really point out to you because someone else is running the slide deck, but if you look to the far left of this image, you see the words cattle guard. From that point all the way leading up to the bridge, that is a slowly rising embankment. So you can imagine there's a wall of a soil and concrete that runs from the cattle guard up to the bridge. And then the little rectangle that you can see, it says building next to it. That's the subject of this litigation. It was used as a grocery store on the bottom floor, and then the top floor was used as a real estate agency. So the weather event in September 1970, we get the area gets a lot of heavy rainfall. The Army Corps of Engineers afterwards just designates it as a 100-year flood event. When this event happened, when the rainfall was happening, the northern dike broke. So we have, a bad situation that's gotten worse. Then you can see here in the corner where the hash marks are the dike that runs north on the New River adjacent to that building. And then that slowly rising embankment ends up turning into being, with the heavy rainfall and the flooding, ends up being essentially a dam that's created, an L-shaped dam. And what happens, of course, is that building floats off of its foundation, it's completely destroyed, and thereby this becomes the subject of the litigation. The plaintiff was the owner of this building, and the plaintiff alleges to the engineer, against the engineer, that the engineer should have designed not only that approach, that slowly rising embankment, but also the adjacent dike to allow water to flow into the New River or to flow southward over that road or through underneath that road by putting culverts into that embankment, which wasn't done. There was also testimony during the trial that at certain parts of the roadway, the water had to pool about 2 feet or more in order for the water to flow over that wall. So the defense in this case, the engineer, as you might imagine, said that this was a 100-year flood event. These conditions weren't foreseeable. He stated, testified that, or the deposition testimony was that he had only contracted to design the bridge to meet 25-year flood event. And in fact, the bridge withstood the flood. So he's telling the court, hey, not only did my bridge and my structure withstand the 25-year flood designation, it withstood a 100-year flood designation. So I shouldn't be negligent. I shouldn't be liable for the destruction of this property. Unfortunately for the engineer, the court did not agree. The engineer was found negligent and liable for the plaintiff's losses. This case was appealed to the Supreme Court of Arizona, and the Supreme Court affirmed that lower court opinion and said, agreed with the court's finding. Next slide, please. So let's look at some of the lessons learned from this particular, from this particular case. So first off, the court said that in a negligence-based claim by a third party, the court said evidence that a flood is a 25-year flood or a 100-year flood is certainly admissible as to the question of foreseeability, but it's not conclusive. So in other words, what the court is saying here is, I will listen to the evidence, that your contract only required you to design to a 25-year flood, but that is not necessarily dispositive on the issue of negligence, which is a much broader question that requires consideration of what you could or should have done, what reasonable professional judgment you should have exercised. The second point here, the court says an engineer or other design professional, by the way, so it's not just engineers that the court was addressing, said that that an engineer does not warrant his service or the tangible evidence of his skill to be merchantable or fit for intended purpose. So what the court was doing here is reminding us that, delivering professional services doesn't involve delivering goods. It's a service. And while you might be able to try to defend yourself saying, I designed a bridge for a 25-year flood event and it survived, even a 100-year flood event, it's not going to be dispositive on the question of negligence. So what I take away from this case, and the reason I like to share it with audiences like yourselves, is that as storms intensify over the coming years, or events intensify over the coming years related to climate change, it's going to be crucial that not only are your designs considering these potential vulnerabilities, and the physical impacts, not to your projects themselves only, but you also have to think about adjacent properties. If you're pushing water somewhere else, how could that potentially be culminate in some sort of claim against you? So thinking about the bigger picture, if I'm pushing water somewhere else, how is that going to impact adjacent properties is going to be an important consideration. Now, the other piece I wanted to say is that you should not count on flood designations to avoid liability. Certainly, it will help you in your defense, but you need to be designing to account for foreseeable future conditions because that's the standard by which you're going to be judged. So the next case study is another interesting one. At first glance, it has nothing to do with climate, yet it has everything to do with climate. And I'll connect the dots for you in a minute. It actually involves asbestos. Next slide, please. So this is the Barnett case, and this was an asbestos case involving an architect where plans and specifications for a school called for sprayed-on asbestos, and the plaintiff in the suit was the decedent's mother. The decedent died of mesothelioma in 1986. The timeline here is really important. So first of all, the architect, as you can see on the right here, was hired to design a school in 1956. The school was completed in 1959. By the way, I know this is an old case, but it's a case that's been cited over and over again in different courts across the country. So it's still very good law. Okay, so the architect was hired in 56, school completed in 1959, and then in the 60s, there were a few publications that started to emerge around the dangers of asbestos, notably after the school was completed. That's an important fact. And then the court noted in this opinion that 14 publications, 14 publications on the dangers of asbestos had been published, again, after the school had been completed, but none of these were published while the school was being designed and built. The decedent attended the school from, you can see here, 1967 to 70, so for 3 years. And then in the 70s and 80s, we start to see congressional and Senate action to regulate and limit the use of asbestos in certain applications. In 1982, the school closes because of asbestos. And then in 1986, as I stated earlier, the decedent died of mesothelioma. There was testimony that the death was linked to its exposures from the school. And the court in this case, now we're in New York. This is the U.S. District Court, Southern District of New York. It was reviewing in this complaint whether the architect should be held liable for the death of the decedent and for specifying asbestos in the school. Unlike the L.H. Bell case, however, the court actually found the architect not negligent and held no liability. So let's look at the reasoning. Next slide, so we can understand how they reasoned this. So the first point here is the court reviewed the defendant architect's performance based on the standard of care in 1959. That was when the school was completed. The second point, the use of asbestos was consistent with generally accepted practices at that time. So the court was very focused in on what were people doing in this area of practice, in this location, geographic location, and what would a reasonable architect have known? And then third here, the court noted that the earliest publication on the dangers of asbestos was in 1964 after the school was completed. And then finally here, the architect could not reasonably have been expected to know the deleterious effects of asbestos between 1956 and 59. So here's where I'm going to connect the dots. Right now, you Google climate or climate change, you're going to get billions of hits online. When I Googled it, it was 1.5 hits on climate change. And of course, not all those hits are going to be relevant to a practice. But my point here is the knowledge of climate risks today is widespread compared to the knowledge of asbestos risks in the late 50s when that project was built. And the fact that the court was reviewing negligence through the lens of what the architect could reasonably have known based on publications and information that were out in the world, in the public domain, this is really important to understand from a climate context, because what it does is it illustrates that courts in a case involving, for example, a flood or some extreme weather event, a wildfire, some injury, property damage, whatever, courts may expect that architects and engineers and other design professionals should know about the risks that we're facing and should be accounting for those risks in their projects at some level. And we're going to talk about that. What is that level? So timing is everything in a negligence analysis. I guess that's the high level point here. when it comes to the question of what courts think you could or should have known and factored into your design. Next slide, please. Okay, so the final case here, hopefully you're still hearing me. There's some construction going on outside my window. I apologize. The final case here is the Conservation Law Foundation versus ExxonMobil case. This case involved Exxon's 110-acre petroleum storage and distribution facility in Everett, Massachusetts, on the Island Inn River. The primary allegation in this complaint, this is, it was a big complaint, and there were many allegations in the complaint, but the primary one was that Exxon was failing to account for climate change factors in managing the terminal in violation of the permit and statutes like the Clean Water Act. If you could click, there's an animation here. There, thank you. Okay, so to operate this terminal, Exxon had to have a permit pursuant to the National Pollutant Discharges Elimination System, NPDES. And this permit was from the EPA, and it essentially allowed Exxon to discharge a certain amount of pollutants into the Island Inn River. A key fact here, again, back to the primary allegation, a key fact was that the pollution permit required Exxon to develop a stormwater pollution prevention plan for the site. And of course, stormwater pollution prevention plan, it's in the name. The intention there is to reduce pollution that flows into the river. And this stormwater plan was to be not only produced by Exxon in order to get the permit to put a certain amount of pollutants in the river, but it had to be annually reviewed using what they called, please click on the next animation. Yeah, there you go. Good engineering practices. And what good engineering practices, how that's defined, unfortunately, was not in any of the EPA regs. And it essentially it left the court in the position of having to hold a full day hearing on what good engineering practice is, especially with regard to the primary allegations complaint. Remember, the plaintiff in this case is saying, you, Exxon, failed to account for climate change in managing this terminal in violation of the permit and statutes like Clean Water Act. There had been no pollution event, by the way. Nothing had happened. Conservation Law Foundation was filing this complaint in anticipation of extreme weather and saying, hey, we don't think you are taking the right steps to fold in changing climate conditions and how you're managing stormwater in order to keep this permit up to date. So let's move to the final slide here. Here's what the court essentially said in this case. So the first point, EPA guidance and practices of engineers in the field as alleged are sufficient to state a plausible claim that good engineering practices include consideration of foreseeable weather events and including any caused by alleged climate change. And then the second point here that I think is really important is the primary defense of Exxon during this full day hearing. And by the way, if anybody wants to read the transcript, I've still got it. I can email it to you. But the primary defense by Exxon in this case was nowhere in this permit does it say I, as a company, have to exercise good engineering practice in relation to climate change. Those words, climate change, are nowhere in the regs. And the court responded in orange here on my slide. The court basically said, after a full day hearing, that the appropriate inquiry is not whether the permit requires consideration of climate change, but whether the permit requires consideration of weather events that the plaintiff is alleging threaten the terminal, including but not limited to those that might be caused by alleged climate change. So the point here is, importantly, is the court is not wading into the fight on is this climate change caused or not. They're extracting themselves and they're saying good engineering practice involve you as thinking about future climate conditions and evolving your knowledge to accommodate those conditions and physical impacts on the buildings, facilities that you're designing and planning. So another really important point in this case, and the reason I'm sharing it, is this is the first time we've seen a court actually meaningfully opine around design practice in a climate change context. And it really shines a light on how courts may analyze the role of climate science or thinking about future climate conditions on building sciences. And the case also was very instructive for us to understand how plaintiffs' lawyers are going to position these types of failure to adapt lawsuits, which are growing in the United States. It gives us information on how those plaintiffs' lawyers are going to make arguments, what documents they're going to say that an engineering firm or a design firm should have known to act on. And specifically in this full day hearing, it was the IPCC reports that we were talking about earlier. It's the fact that there were state adaptation reports. So Massachusetts had a state adaptation plan, had a hazard mitigation plan. It was the NOAA data that I shared with you on my very first slide. These are the kinds of reports and information that courts see as meaningfully helping design firms understand what future climate conditions will be. So with that, there are also a number of other lawsuits that are pending like this that are still pending. We're going to keep our eyes on that, but I'll turn it over now to my co-presenters with the law firm of Collins & Collins. Thank you so much for your attention.
Thanks, Yvonne. Next slide, please. My name is Jessica Mead, and I'm a partner at Collins & Collins. We're a private law firm that specializes in representing design professionals. Today, I'm going to go over California-specific jurisprudence and the impact of the increase in severe weather events on duty and the standard of care. I'm going to start by going through the types of claims that can follow severe weather events, as well as the recoverable damages, and then go through the typical cause of actions that are asserted against design professionals. I'm then going to talk about a couple of cases, California-specific cases, that address how the existence of a contract is becoming less important in being able to state a claim against a design professional, and how when a contract is not required, the foreseeability of harm, which becomes important as severe weather events become more common, is the critical factor in whether a design professional can be exposed to damages. Next slide, please. So there's a number of claims that can be brought after a severe weather event occurs. As Yvonne knows, the first type of claim that you would think about would be claims against insurance companies. It's also common to assert claims against public entities and utility companies based on the theory that either government action or inaction or infrastructure contributed to the property damage. And after these most recent wildfires in California, I'm sure you've seen advertisements from plaintiffs' firms inviting people who have been affected to join in class actions against public entities and utility companies. There can also be claims brought against property owners, and this can be either by tenants, people on the property when the severe weather event occurred, or by adjacent property owners claiming that there was some condition on an adjoining property that damaged their property following a severe weather event. There can be claims brought against contractors based on the failure to properly construct or install. And finally, there can be claims brought against design professionals based on the theory that the design negligently failed to account for a severe weather event. Next slide. There's also a wide array of potentially recoverable damages after a weather event. And these can range from property damages, which would include repair costs, displacement expenses, potentially loss of profits, depending on the property that was damaged, as well as potential punitive damages, depending on the blameworthiness of the defendant's conduct. Punitive damages are awarded to punish and can be much greater than the actual damages that the claimant suffered. There may also be personal injury damages, which would include loss of wages, medical expenses, and emotional distress suffered due to the injury. And depending on the facts, you may also have damages due to the death of family members. The recoverable damages are largely going to turn on what causes of action are available. So I'm going to go through the two causes of action that you primarily see brought against design professionals. Next slide. Historically in California, the only claims that could be brought against a design professional were breach of contract claims. And that meant that only individuals that had a contract with the design professional could assert a claim against them. Also, with breach of contract causes of action, the recoverable damages are limited to contract damages. So you're not going to see claims for emotional distress or punitive damages. And it's possible to use language in the contract to limit recoverable damages, which Brian's going to go through in more detail in the next section. Next slide. There's also now negligence cause of action being brought against design professionals, even where there is no contractual relationship between the plaintiff and the design professional. But regardless of the existence of a contract, there still needs to be a duty, which means that there's some kind of special relationship between the plaintiff and the design professional where harm to the plaintiff is foreseeable. The plaintiff also needs to prove that the design professional acted negligently, which means that they breached the professional standard of care. As severe weather events become more common and projects go beyond code to design for resilience, it's going to be harder to argue that merely satisfying the code is sufficient to meet the standard of care. The breach of the professional standard of care also has to cause actual damages, which are either property damages or personal injury damages. You can't state a negligence claim based on pure economic damages, like if a project took longer than anticipated or is more expensive than anticipated, but there was no associated property damages. Next slide. The cases that I'm going to go over are going to focus on the duty element of negligence claims and how the foreseeability of harm factors into the duty analysis. The duty requirement exists to limit what would otherwise be potentially infinite liability for every negligent act. So the issue with duty is whether at the time of the negligent act was the type of harm that occurred foreseeable, so that it would be fair to hold the defendant responsible for the plaintiff's injury. So where no contract exists, courts will look at a number of factors to decide whether the plaintiff can still bring a negligence claim. So these are, was it foreseeable that the plaintiff could be harmed by the defendant's conduct? Was the design professional services intended to benefit this plaintiff? Was the harm that occurred foreseeable at the time the design professional performed their services? And is it clear from the fact that the plaintiff suffered harm due to the design professional services? Courts also look at the moral blame that can be attributed to the defendant's conduct in deciding whether duty exists, as well as whether finding that a duty exists would help further a policy of preventing future harm. So now I'm going to go through a couple of California cases that discuss design professional liability when no contract exists, so you can see how foreseeability of harm plays into a court's willingness to allow negligence claims to go forward. Next slide. The first case I'm going to talk about is a California Supreme Court case that was decided in 2014, Beacon Residential versus Skidmore. And this case involved an architectural firm that designed a condominium complex under a contract with a developer, and the condos were later sold to individual owners. The owners brought a negligence claim against the architect, claiming that the units were uninhabitable during certain months due to the high heat. And the California Supreme Court held for the first time that the architects owed a duty to the owners despite the lack of contractual relationship. Next slide. In the Beacon case, the defendants were the only architects on the project, and they were paid $5 million for their design services, as well as their ongoing role during the construction. The project involved a high-rise condo complex in San Francisco. So historically, it would be fair to assume that you wouldn't need air conditioning, and San Francisco is very cold. But as the weather has changed, the plaintiffs claimed that during the warmer months, it was too hot to be in the condo units. And the architects argued that since the developer had the final authority to make the call on whether or not there would be air conditioning in the units, they couldn't owe a duty to the owners. And next slide, please. And the court rejected that argument and found even though no contract existed between the architect and the owners, and even though the developer had the final decision-making authority, the architect owed a duty of care to future homeowners when the design involves a residential building and when the architect is the principal architect. And next slide. And in coming to that holding, the Beacon Court went through the same duty factors that we discussed earlier. It found that it was foreseeable that the owners could be harmed by the architect's conduct because the architect's design was intended to benefit the condo owners. They found it was foreseeable that an inadequate design by the architect could harm future owners, and that based on the allegations, the architect's design without air conditioning made the units uninhabitable and unsafe during high temperatures. The court also found that since the defendants were the principal and sole architects, there was a close connection between their conduct and their design and the plaintiff's injury. And it also found that there was a good amount of moral blame attributable to the architect's design based on the highly specialized training that an architect has, and that they should have been able to design units that were safe for habitation. The court also found that finding a duty would further the policy of preventing future harm to homeowners. Next slide. The next case that I'm going to go over with you was decided more recently in 2024, and it shows how the Beacon holding has been further expanded to find that a duty exists even when there's no contract. Next slide. In Lynch, the homeowner hired a contractor to remodel their home, and it involved expanding the foundation of the home. And initially, the contractor had solicited a proposal from a geotechnical firm. And as part of the response to the proposal, that geotechnical firm noted that the home was located in a landslide area. At some point, a new contractor was hired, and they hired a different geotechnical engineering firm to perform a really limited role and inspect the footing of an excavated trench. The geotechnical engineer prepared a memo stating that the excavated trenches had suitable material for the intended use. And ultimately, the footing didn't hold and the house subsided, which created significant cracks to the floor and the foundation. Next slide. In the Lynch case, the geotechnical engineer's contract also had significant limitations in the scope of work. It expressly excluded subsurface exploration, lab testing, and settlement analysis. And the contract also expressly stated that the geotechnical engineer would not be responsible for potential settlement or slope failure. It also contained a limitation of liability clause to twice the $360 fee that the geotechnical engineer was paid on that project. Next slide. And the court found that even though the geotechnical engineer was not the principal architect and was paid a minimal amount for a very limited scope of work, it still owed a duty of care to the homeowner so that the homeowner could proceed in bringing a negligence claim. And the court found that the limitation of liability clause in the contract wouldn't be binding on the homeowner who was not a party to the contract with the geotechnical engineer. And this is clearly an expansion of Beacon holding, where the court limited its holding to duty owed to the duty owed by the principal architects based on the close connection between a principal architect's design and injury following the design. Here, the geotechnical engineer just performed one limited inspection. The Beacon court had also relied on the fact that the architects were paid $5 million for their specialized skill to find moral blameworthiness, whereas here the geotechnical engineer was just paid a very minimal $360 fee. Next slide. The Lynch court went through the same factors that the Beacon court went through to find that a duty existed. It found that the homeowner foreseeably could be harmed by the geotechnical engineer's conduct because the geotechnical engineer's services were intended to benefit the homeowner. And it also found that the harm was foreseeable because if the work was not done properly, because the home was situated in an area known to be prone to landslides. So the court considered the site conditions and the type of damage that could occur in this case to find that the harm was sufficiently foreseeable. And this is important to keep in mind, especially for designs for rebuilding homes in the Palisades and Altadena areas, because the reasoning in Lynch opens up the potential for courts to find that in future cases, the design of a residence that's known to be in a severe fire risk area could foreseeably result in fire damage if the potential for fire is not accounted for in the design. The Lynch court also found that it was clear that harm occurred from the geotechnical engineer's conduct since the home subsided and the footing didn't hold, and that there was moral blame based on the contract exclusions. The court found that the work that the geotechnical engineer excluded from their scope of services was necessary to satisfy the professional standard of care to perform the inspection. The court also found, like in Beacon, finding the existence of a duty would further the policy of preventing harm to future homeowners. Next slide. So the key takeaways to keep in mind here are that a plaintiff can bring a claim against a design professional even if no contract exists. And this is especially true in the residential context where the plaintiff is a homeowner. So it's important to consider potential exposure to future homeowners when making design recommendations to a developer, because that duty can exist even though the developer is the one that has final decision-making authority. You also want to be careful when you're preparing your scope of work that you're not excluding services that could be considered necessary to satisfy the professional standard of care. And now I'm going to turn it over to Brian Stewart.
Thank you, Jessica. Welcome, everyone. Next slide, please. Little background on me. I'm the managing partner of Collins & Collins. I've been practicing for 38 years plus. I review a lot of contracts for architects and engineers in the community. In my mind, I probably, and it ebbs and flows a little bit, but probably about 5 to 10 a month now. So I'm looking at this stuff all the time. A little levity to get us started. You must review the fine print. Next slide, please. Here's an overview and a historical perspective on this stuff. Some of this is because of history, and some of this is because I'm so old that I know some history. Contracts always need to be in writing. Sometime back, I don't remember how many years ago, the California legislature in its infinite wisdom determined that architects and engineers must have their contracts in writing. Actually, some good legislation. There are exceptions to that, but I encourage people, irrespective of the legislation, to always have your agreements in writing. They should always be discussed and negotiated. It's great if you can get somebody to sign a contract, but there's things, especially in resilient design, that should be discussed. And remember, folks, when you're busy, and I venture to say most architects and engineers in this community, certainly my clients are extremely busy, it's easier for you to say no. That's whether it's no to the whole project, whether it's to say no because you don't like the person after you get to know them a little bit that's trying to hire you, or no to a certain clause that you think is over the top. Scope is often not focused on enough. And in resilient design, it takes on a sort of a new meaning. Not only what you will do, but what you will not do and what you will not be responsible for. And the last thing, people have asked me frequently, how long should I keep my documents, especially as to contracts? Get them executed. I have multiple cases over my career where it's signed by one side but not the other, and save it forever. Storage is very cheap these days, as folks understand generally in terms of cloud storage and the like. Next slide. Just a couple of hot ticket items that we're going to talk about today: limitation liability, indemnity, duty to defend, prevailing party attorney, and expert fees. Next slide. So what brings us all together? Natural disasters. As Yvonne pointed out, they seem to be accelerating. There seems to be more of them. That chart from NOAA was very, very instructive in terms of the amount of claims, the size of the claims, the frequency of the claims. Everything's happening faster and faster. All I need to do is look out my window to the north, and I can see on the horizon Altadena, California. I'm on the 6th floor of a building in Pasadena, facing north, and I can actually see the burn zone from here. It's not a pretty sight. Next slide. All right, how to contractually mitigate your risk. First of all, you can never completely get rid of your risk. The best you can hope to do is mitigate it. If you don't want to have any risk, don't take on any work. Well, that's sort of ridiculous. You want to do work, you want to do good work. So you need to define the standard of care in your agreement. Better said, don't let the owner define the standard of care in a way that you're not willing, or you can get in trouble with your insurance company in terms of overpromising. So California, the state of California, in its legal layout, there's something called CAISY, we're going to talk about in a minute, which is the California Approved Jury Instructions. And they have some very good standard of care definitions we'll talk about in a minute for architects and engineers in California. Again, the scope. What are you doing and what are you not doing? An example I used that came on the scene quite a few years ago now, but most of you are familiar with it, is LEED. Don't guarantee you're going to obtain LEED Platinum. I recommend all clients say you're going to strive for it, or the goal is, things like that. Guaranteeing is a dangerous thing to do, because in California, you're not, as a professional, held to a warranty standard unless you make a warranty or a guarantee. So, with regard to resilient design, the standard of care is always moving. It seems to be accelerating lately, particularly because of the things that Yvonne laid out in the beginning of the program. The acceleration of severe weather. Certainly here in Southern California, there is nobody that doesn't know somebody that lost their house around here. I mean, it's a metropolis, the whole area of probably in excess of 10 million people, but everybody knows somebody, and I know multiple people that lost their houses. So for over a period of time, it'll sort of move slow. And then what I think we're going to get out of this, and we're still just in the very earliest stages of it, we're going to get an acceleration that will affect the standard of care. That's my prediction. And it's going to move following hurricanes if you're in another part of the world, if you're in Louisiana, if you're in Florida, the Carolinas. All of these weather events are going to color and affect the standard of care. Next slide. These are the jury instructions I was telling you about, and I've used these successfully in many, many cases over the years. They read just almost exactly like this, except in saying the generic, a design professional, it'll say an architect, or it'll say an engineer. And this is the standard jury instruction that any architect that gets sued in California for negligence has the ability to use, and almost certainly the court will approve it. The exception is if you agreed to a higher or more restricted standard of care, which you should never do contractually. But I highlighted the part of this that I like, or I want to focus on. You must determine the level of skill and care that a reasonably careful design professional would use in similar circumstances based only on the testimony of the expert witnesses. Each side hires an expert. In order to sue a professional in California, one must have an expert in the same discipline, an architect to sue an architect, that has rendered an opinion that the architect, usually our client, fell below the standard of care. But then it adds, including the design professional named in this action who have testified in this case. Because it's not a criminal case, we're dealing with civil cases. In almost every instance, frankly, every instance, I've ever tried a case, and I've tried many of them, my client testifies that they met the standard of care. So that is the information a jury has to rely on, the experts and our client. Next slide. The KC 602 instructions, even, I guess, the one I use the most, it basically says just because you make a mistake as an architect, or your project was unsuccessful, or you made an error, as long as it was reasonable under circumstances, it doesn't equate to negligence. You don't have to be perfect in California as an architect or an engineer, unless, of course, you signed a contract where you agreed to be. So don't do that. Next slide. No contracts are perfect. Long ones don't necessarily get you across the finish line in a good way. Usually it's worse. Meeting of the minds is critical. What did the parties intend when they executed the agreement? And there's no magic language yet in terms of dealing with resilient design, but everything old is new again. So some of the tried and true that we're talking about here today apply to resilient design. Also, there's been talk about code. Just because you design to code, it's equivalent of a C grade on a paper. Designing to code, there are experts out there in the community who will say designing to code is insufficient. You must design above the code, and it's professional negligence to design to code. I know that's hard for some of you to believe, but there are experts that will testify to that. However, if you design under the code and you don't meet the code, it's a slam dunk loser. Next slide. There is a code section that I referred to earlier for architects that gives very specifically in the business and professions code section exactly the minimum requirements for an architect in California. There's another section for engineers, but I'm not going to read this, but if you go to the earlier slide, these are the requirements. You got to have a description of the project. Number 2 covers scope. Number 3 covers how you're going to get paid. Pretty important. Number 4, you got to put your license number. A lot of clients just put their company down and sign it. A registered architect on an architectural agreement to provide architectural services in California must include the license number of the architect that's in responsible charge of the project. Next slide. How are you going to do changes at number 5? Change orders have to be detailed in how it's going to work. 6, how are you going to terminate the agreement? I'm a big advocate for either party can terminate the project at any time for any reason on 7 days written notice. If you can swing that, you really should do it. Number 7 is copyright related, and you should have definitive statements on that in your agreement, and you have to under this law. And then this piece is a bit silly, but it's a requirement in all California contracts. Unless there's an exception between an owner and an architect, you have to put that language in a certain point type. Otherwise, you're in technical violation of the code. Next slide. Other important clauses. The first one I think is very important, especially as a lot of my clients are getting to the point in their careers where they're about ready to retire or close to it. You don't want to have personal exposure to you or your registered architects if you can avoid it. Second bullet point, limitation liability. It's viable in California. You can limit your liability by contract. Third bullet point, mutual consequential damage waiver and beyond. See if you can get even more waived. Arbitration or litigation is an age-old question. I'm a litigation guy for reasons we'll talk about. And indemnity. Next slide. Exculpation clause, fancy phrase for how do we not have personal liability to our registered professionals. This is a clause that gets you to that point, whereby, let's say you have a corporation, professional architectural corporation, and you're providing services, but you're the registered architect. You have personal exposure. You can be sued directly. Unfortunately, lawyers, doctors, engineers, accountants, registered professionals in general, surveyors, can be sued personally, even though they have corporate protection. This is a clause that you should seriously consider. But every contract's different, every situation's different. So while you're probably going to get this slide deck, got to be very careful on using this language and know how you're using it and where you're using it. Next. Next slide. Oh, you're on that slide. I'm sorry. I blinked. Go back. Limitation liability. This also is one that you can use and you should use. Clients say they have mixed results in terms of getting owners to sign off. I will tell you that public agencies almost never sign these. I will never say never. Private clients are oftentimes more willing to sign them. And if you don't ask, you don't get. So I strongly encourage people, especially if you're doing high risk work, to get a limitation liability clause in place. Next slide. Mutual consequential damage waiver. I added other things in here, including waiver of punitive damages. This is one where I'm going to tell you that the AIA documents are a great place to start. The consequential damage waiver, in my opinion, in the AIA standard documents, doesn't quite go far enough. Starting at the 6th line, 7th, there is language that says towards the right, this mutual waiver of consequential damages shall include but not be limited to loss of use, loss of profits, loss of business, loss of income, loss of reputation, delay, et cetera, et cetera. I think that does a better job than the AIA standard documents in more fully informing people who, if there's a lawsuit, will later claim, I didn't understand what consequential damages meant. So you want to fill that out. And this is why you can't just cookie cutter this language. Every project's different. Every risk is different. You got to look at your project and determine what other terms or phrases should be added given the nature of the project, its location, its risk of fire, its risk of flood, things like that. Next slide. All right. Mediation first is a given. Should try to mediate and settle disputes before any lawsuits filed. Unfortunately, it doesn't always work. The standard you must mediate first clauses in the AIA agreements sometimes are a hazard in the sense of if you're owed some small amount of money, the contract will force you to mediate first. Not always a terrible thing, but sometimes an inconvenience. Arbitration is disfavored for lots of reasons. Most insurance carriers do not favor arbitration. Remember years ago, those of you that have been around a while, the arbitration was baked into the AIA standard agreement. I don't remember the year, but maybe 2 cycles ago, it got changed where it's you pick A, B, or C, litigation, arbitration, or other. Because it used to be faster, it used to be cheaper, it used to be fair, and you have no right to appeal. I don't think it's any of those first 3 bullet points. I don't think it's cheaper, I don't think it's faster, and I certainly don't think it's fair in a general sense. Litigation just has more protections, starting with jurors don't owe anybody nothing. If you pick an arbitrator in the community, one of the things that can happen is they work with both law firms. So are they going to color their result based on who they get more business from? I'm not saying it happens. I'm just suggesting it might happen. And you preserve a right to appeal. That is very, very important. Next slide. Indemnity, the duty to defend. We're not going to be able to get into this. Time is short. The key thing is when you can avoid it, avoid it. Try not to have any contractual indemnity. If not, you need to have a negligence trigger to protect you in terms of covering for insurance, your insurance if you get sued. And you don't want any immediate duty to defend baked into any indemnity clause you sign. You should also make it reciprocal if you can at all. And there's a code section that came out a few years ago, which I had the privilege of sitting on subcommittees for ACEC and for AIA California that got it passed. And it does a great deal to help protect design professionals from uncovered, meaning uninsured losses in the indemnity realm. But it doesn't cover contracts with the state or the federal government. Next slide. Design your contract to match your risk. What are you doing? Are you designing a new home in Malibu? If you are, you might want to have conversations about the risk of fire. You might want to make recommendations of things that would mitigate the fire risk, both on the exterior. Does your scope just involve the building envelope? Does it involve the building envelope and the areas around it? What about hardscape? What about a pool? What about one of those pumps that are becoming pretty popular that allow one to pump water and aid in fire suppression? All kinds of things are and the standard of practice and the codes are going to change significantly, I believe, as we get through this rebuilding effort in Southern California. You want to lay things out in your contract to match the anticipated risk you're taking on. And the last point I say, the project is, you might even want to include this in your contract, certainly in a cover letter. But contract's always better. Putting things in a cover letter that aren't in the body of the contract, because most contracts have clauses that mandate if it's not in that contract, the four corners of the contract, it's irrelevant. So you want to get this stuff in the contract. Next slide. As I said, when I started, everything old is new again. The same rules of engagement in terms of contracts. You need good language. And do not overpromise and underdeliver. If anything, underpromise and overdeliver. Important, try to exclude personal exposure contractually if you can. Most clients will allow that. Most owners will accept that. There's some that won't, and then you got to ask yourself, do I really want to be in a contract with somebody who wants me, not my company, to be personally exposed? You all need to keep up with the standard of care as it evolves, and it will evolve. And geography makes a big difference. The last point before my last slide is owners, insurers, and banks are going to demand resilient design going forward. You good people just need to keep up. Plenty of opportunities and plenty of business. Just try to keep ahead of it, stay smart, and protect yourselves while doing it. Last slide. Like I said, insurance is going to drive this thing, and lots of interesting things are going to come out of this in terms of the property and casualty market, what they're going to cover, what they're not going to cover, how are we going to get insurance in California. It's a very interesting time to be dealing with this stuff, and a very unfortunate time for many people, to whom I wish all the best going forward. My time is over, and I'm going to turn it back to Yvonne. Thank you.
Thank you, Brian. Appreciate that. That was, I think everything that Brian and Jessica just said about the cases, contract mitigation clauses, all of that. Unfortunately, I don't have time to cover either, but I think that was an excellent overview of ways you can mitigate your risk. Next slide, please. So I'm going to wrap up here in just a few minutes, at least on this portion of the program. The big picture here is this is what the standard of care would normally look like without climate change and the physical risk challenges that we've been talking about. As many questions came through on the chat, following code is the absolute minimum standard. It's table stakes. There are cases that say you may be per se negligent if you don't follow code. But to meet the actual standard of care, as you can see in this image, it's exercising reasonable professional judgment, as Brian and Jessica explained. And notably, I think one thing maybe people we should emphasize here is that even if you're practicing in a jurisdiction where the latest, most modernized codes have been adopted, most building codes, as I mentioned earlier, these are largely based off of historical weather data, not future forward projection data. And that well-known fact is one big reason that we are advising our clients that the standard of care is evolving, and it looks more like the next slide. If you could please advance. Where I'm adding in a review climate projection data and resources as sort of fundamental to the standard of care in the climate change context. Basically, my point here is that until actually codes can catch up and integrate future forward climate data projections, we believe that firms should be considering adding more tools to their toolbox just as an additional layer of due diligence in order to mitigate the physical impacts of increasingly severe weather events that we're going to see, and also just to bolster your credibility. It's not just about risks here. We believe this is an opportunity for the architectural profession to build your credibility and to build out additional services in this changing and new environment. And hopefully to avoid, by exercising this additional due diligence, hopefully you can avoid a liability outcome in a negligence suit. I think Brian or Jessica said earlier, there's nothing that we can do today to help you avoid a lawsuit. But what we can do is help you mitigate your exposure and hopefully get you out of that lawsuit quicker. The types of resources that I would recommend you consider reviewing if you're not already, and there's plenty of standards out there also to review, but in terms of the climate science, reviewing the IPCC regional reports that I talked about earlier. You can get that through the IPCC website for the United States. Climate mapping for resilience and adaptation, CMRA. You can look at the U.S. National Climate Assessment. NOAA has plenty of tools, the Climate Explorer, Sea Level Rise Viewer, Heat Risk Map. I'm sure you're familiar with wildfire risk to communities. This is a USDA resource, and I know California has a ton of wildfire risk related resources as well. The FEMA National Risk Index, and then climate modeling. I'll give you a little information on a secret. The AIA Trust and the American Institute of Architects are working heavily right now as we speak to deliver a climate modeling service to its members in Q2. You're going to have to stay tuned on that. We've been working with the trust to help deliver such a service. But so my point here is there's a lot of resources online. I think there was a question that came through about, the federal administration, the federal government having new priorities. Unfortunately, I do think that's something that you're going to have to think about. As far as I know, these resources are still, if you find them on, if you click to them online, you're going to find them. The websites are still active. But yes, it's an evolving landscape on that side. So I don't know what to tell you other than we're going to keep moving forward. And hopefully the good work of NOAA and other agencies at the federal level will continue to be available for you. My final slide, next slide. 3 easy steps for you to manage some of this stuff. And I shouldn't say easy. There are 3 very clear steps to help you through this, because this is a lot. We recognize that. It's 3 steps: see, say, and save. See the risks. So educate yourself on these future forward climate data pieces, the intelligence that's out there online. So see the risks, educate yourself. And I don't mean you need to be a climate expert. I mean spend 1 or 2, 3 hours on a project, understanding what those projections look like for your particular site, even if it's high level information. And then once you understand what those projections are for your general region or your project site, if you're doing a climate modeling exercise, say something. You have to flag the things that you learn in that process, flag those risks with your client, and then shift the burden to them. Give them the choice to act on resiliency measures. I know there was a question about that as well. all you can do is present the information that there are risks out there, that you're not providing predictive information, but that you have done your due diligence to see what the future holds for this particular project site and location, generally speaking. You can flag those risks, you have your clients consider that. You can even make recommendations for hiring sub-consultants or doing additional services for your own firm, building out those additional services, but give them the choice. And then especially those clients that say, no, thank you, I appreciate the information, I do not want to invest in adaptation or resiliency, document those conversations, append them to your contracts, and have that proof. So in the event you find yourself in some sort of litigation, now you have something that you